a company that helped in renditions, because they're trying to get some justice for themselves after they've been renditioned into really horrible torture. And surprisingly, the Obama administration took the same position the Bush administration did, which was that this case couldn't go forward because it would violate national security, and so they invoked state secrets in that case. I mean, there's been, all of us are watching this closely to sort of figure out where the Obama administration is. I think I'm probably more sympathetic to what they're doing than many of the critics have been, including even a piece recently in the New York Times. I mean, I think what they're trying to do is move forward in the right direction and not relitigate what happened in the past. I think the past has to be dealt with, personally. I think there needs to be some more accountability there, and I hope they move towards that situation. In that state secrets case, it's complicated. The problem is that what they're dealing with there is that the CIA worked with other countries, particularly Morocco in that case, I think. And the feeling was, if the CIA, if in an open court we begin to describe all the liaison relationships that the CIA has with other countries are not going to allow the CIA to operate with them. And they thought that there were it was a rotten position to be stuck in. And I think that's what you were looking at there. So I mean, it's worth criticizing, but I think it's also these questions that are left for them to defend are really awful.
Jane Mayer, we're also joined by Glenn Greenwald. After a month in office, the Obama administration surprised many of its supporters by embracing key parts of the Bush administration's counterterrorism strategy. Obama's nominee for Solicitor General, Anna Kagan, has publicly endorsed Bush's policy of indefinitely detaining suspected al-Qaeda members regardless of where they're captured. And CIA Director Leon Panetta has said the CIA might continue its extraordinary rendition program. The Obama administration has used the state secrets doctrine, as you were saying, Jane, to urge a federal judge to toss out a lawsuit by former CIA detainees and to prevent a federal court from reviewing the Bush administration's warrantless spying program. To discuss this, we're joined by Glenn Greenwald, constitutional law attorney and political and legal blogger for Salon.com, author of 3 books, his latest, Great American Hypocrites, Toppling the Big Myths of Republican Politics. He's joining us by video chat from his home in Brazil. We hope the audio is good enough. Hi, Glenn. I don't know if you've heard Jane Mayer speaking, but talking about the issue of state secrets, can you talk about your concerns?
Well, I think the biggest concern is not so much that the Obama administration thought there might be legitimate secrets to protect in this case, whether it's specific rendition agreements with Morocco, as Jane alluded to. The problem is that there are 2 ways to use the state secrets privilege. One is the traditional way that had been used since before the Bush administration, since 1953, which is to assert on a document-by-document basis that specific pieces of information are too classified and too secret to be allowed to be used in a judicial proceeding, and therefore they ought to be deemed privileged the way that, say, attorney-client documents are, or doctor-patient communications are. Very specific and focused assertions of privilege over a specific document. I don't think anybody, the ACLU or civil libertarians, have a problem with the assertion of privilege when it's used in that way. The problem is that what the Bush administration did is they converted a state secret privilege from a document-specific means of excluding pieces of evidence to a shield of immunity to compel courts to dismiss entire lawsuits before there's any proceedings at all, any effort to find out whether specific documents really are classified, whether there's a way to allow the plaintiffs to proceed and have their day in court without using classified information. That's been the controversy over the use of the privilege as a shield of immunity to protect the president from judicial accountability, and it's the Obama administration's embrace of that theory, of that use of the privilege as a weapon, that has been so disturbing. Had they really been concerned about specific agreements with Morocco, they could have simply said, well, send the case back to the district court, and with regard to specific documents, we will assert the privilege over them. That's not what they did. They embraced what they had long said was the abuse of the privilege when in the hands of the Bush officials.
And in the case of Binyam Mohammed, you've written how specifically the Obama administration has even joined in threatening Britain in terms of its possible release of information about activities that have occurred in the past. Can you talk about that?
Yeah, that might actually be the most disturbing episode yet. I mean, the British government has acknowledged that it has in its possession what it calls exculpatory evidence with regard to Mohammed, namely information that it obtained from the CIA that the confessions on which the Bush administration previously was relying to prosecute Mohammed in the military commission were confessions that were obtained by very brutal torture, not waterboarding, not forced nudity or hypothermia, but hardcore, violent, brutal torture, including things like having his genitals sliced and being severely beaten and threatened at gunpoint. And the British government said that they had this in their possession, but they refused to turn it over. The American government had refused to give him access to any of that information so that he could defend himself. And so Mohammed went to a British court, and the British court said that he's absolutely entitled to these documents, that international law and British common law do not allow countries to conceal evidence of torture and to send somebody into a military commission where the death penalty might be imposed and conceal documents that they might use to defend themselves. And after the British court ruled that way, the British government said, well, the reason we can't turn over these documents is because doing so would harm British national security, because the American government has threatened that if we conceal these, if we disclose these documents or reveal to the world the facts and information that we have about how he was tortured, that they will terminate intelligence sharing programs with us. Meaning if they learn of a potential terrorist threat directed at British citizens or at our country, the American government won't tell us any longer about the information that it receives. And the British court said, well, given those threats and given our obligation to protect British national security, we actually agree that these facts need to be concealed, and we're going to keep out of our court decision any information shedding light on how Mohammed was tortured at the hands of American agents. And amazingly, the Obama administration issued a statement congratulating and praising the British government for keeping those secrets and essentially reaffirming the threat by saying, now that you've agreed to keep this secret, we will continue our intelligence sharing program.
Jane Mayer, your response to Glenn Greenwald's take on this?
Well, I mean, I think, I'm a big fan of Glenn's writings and follow it closely. I think, basically this whole setup during the Bush years was a criminal situation where you've got our government working with other governments doing things that were war crimes and violations of all kinds of rights. And the question for the Obama administration is whether they're going to treat these things as criminal or are they going to, they're on the spot, are they going to cover them up? Right now, they're trying to move forward and not get bogged down in what they see as something that's divisive, politically poisonous, a political problem for them. I think it's going to turn out to be a mistake for them to do this. I think because these questions are going to keep popping up again and again. I mean, there are many other cases of detainees who also want to try to get some justice. I mean, there's the Maher Arar case, the detainee who was renditioned, the Canadian, who has been unable to get any kind of justice. There's Khalid El-Masri, who was a German car salesman who was renditioned by the CIA. These people are all going to try to get some sort of justice for themselves. And I think the Obama administration, there are many, many other cases too, is going to have to set up some mechanism to deal with this. And they, I'm giving them maybe a little bit more credit than Glenn is, because I think what they did in their first week in office was stupendous. They put out executive orders that said from here on out, everybody's got rights, everybody's covered by the Geneva Conventions, the ICRC gets to see every detainee, we're closing the black site prisons, we're going to shut down Guantanamo. They are moving on. These things are not nothing. These things are really seriously great reforms. And so, the issue where things are getting hung up is in this issue of backwards looking, what should we do with the criminal actions of the past, and do they get covered up, or is there going to be some kind of investigation and some kind of accountability. And I think that's very much in play.
Glenn Greenwald, last word, and if you could also address rendition in that.
Yeah, I mean, I actually agree with Jane that it's a mixed picture, more than perhaps, my answer might have suggested, because I was addressing two specific areas where I think the Obama administration